The attorney that will be leading our class is Mark Gomez. Come on up.
All right.
Thank you so much, sir.
Thank you. Hey everybody, thank you for showing up today. It was really hot outside. I'm gonna actually have to talk to Mariana about the warranty stuff, because I have a home and the AC is just blown over in Yucca. So my warranty person's like, I gotta use this person. I gotta wait 2 weeks. It's a nightmare. So yeah, thanks for being here, and I'm excited that everybody wants to learn more about law. Hopefully, after today's presentation, you'll come away knowing a little bit more about certain topics and themes. And so if you come across these issues, you can come across more trustworthy, right, to your clients, because it's all about building trust and having that background. If you come across a situation, hopefully you'll know how to advise them. So my law firm is Gomez Law. We're based over in Los Angeles off of Wilshire. And we cover cases all throughout LA County, Orange County, and Inland Empire. If you'd like a copy of this presentation, go ahead and email us at social@gomezlawla.com. All right, today's topics are going to cover probate, dual agency, partition disputes, clearing title, and foreclosures. A little bit about myself. I'm a real estate focused attorney for the last 10 years. I'm a current member of the California Lawyers Association Real Estate Litigation Committee, where I recently did an article on bona fide purchasers and inquiry notice. So if someone is buying a property, what are the rights for the people that are in the property. So that article is going to be coming out pretty soon. And I'm a published attorney. I had a case, Valbuena versus Ocwen, where we filed a wrongful foreclosure lawsuit, and we're able to go ahead and get the foreclosure reversed, get the homeowner back into the home. And that case is still good law in California, so it's being cited in the courts right now by other attorneys, which is pretty cool. I was also nominated for the Super Lawyers Rising Stars in 2022, so that was pretty awesome. All right, so the next first topic is probate for real estate agents. Just give you some background. What is probate? Right? Probate is the court-supervised process of reviewing a deceased person's assets and making sure they get distributed to the rightful heirs. The rightful heirs include the people or organizations the deceased may have named in their will. So basically, someone dies, what happens to their stuff, right? The decedent's estate is their house, their bank accounts, and it can include their personal belongings and automobiles. So that stuff has to go through probate unless there's a trust, right? Then you could go ahead and avoid probate, or it's less than a certain amount of money in the total estate. So has anybody kind of dealt with probate before or got any listings through probate? Yeah, good. How does probate affect your real estate practice? So if there's a contest of title in the property, a seller may need to go through probate court in order to transfer legal title to the buyer in question. So a common fact scenario is, hey, I get a call from someone, they're not on title, their parent has died, or we need to go through probate to clean up and figure out who's the rightful person to sell that property. Almost $2 billion is spent on probate costs every year, and that's just probate attorneys, that's court filing fees, so that's just the costs associated. You have to imagine how much property is being transferred, right? We're gonna have this big transfer of wealth, and so this is a massive opportunity, in my opinion, for real estate agents to go ahead and learn a little bit of background and know that, hey, if you have a client that calls, my relative just passed away, what do I do? Now, hopefully, after this, you'll have a little bit more background. In the state of California, if the estate involves 184,500 assets or more, then it has to go through probate. If it's less, then there's a little petition that you can file that's pretty quick. All right, hypothetical, let's say John owned a home. He told Amy several times that she will inherit his home instead of his two other children, Bob and Charlie. Unfortunately, John dies, and the will that he left makes no mention of this promise to Amy, but Amy wants to sell the home, right? So what do you think the next step Amy needs to do to sell the home? Any takers?
Go to probate.
Go to probate. Yeah. So you have to file the probate petition and likely an 850 petition to go in if she wants to make a claim, right, that the property should go entirely to her instead of the other two heirs, as promised by the decedent. All right, traditional home sales versus probate home sales. As you guys all know, for traditional home sales, you're going to list the property, And in this market, you're probably getting maybe a couple months to maybe get a real solid offer. But then you have a 30 to 60 day escrow period. And then once all the documents are signed, escrow is ready, you can go ahead and close. You don't need any third-party court supervision, of course. However, in probate, that's different, right? The executor or the personal representative of the estate is the one that has to manage and act in the best interest of the estate. And all of this is supervised by the court. You must go ahead and follow certain probate laws and take certain initiatives that the probate court judge wants you to take. It's a pretty long process, and of course there's going to be uncertainty with buyers, because they don't know how long the process is going to last. Even if they put in an offer and it gets accepted, is it going to go ahead and be authorized by the judge? Most of the time it is, but it's just something for buyers to go and be on notice of. And of course the home's got to be confirmed, the home sale's got to be confirmed by the court. When a seller wants to sell a probate property through a real estate agency, so most sales in probate are going to go through a regular real estate agent and a brokerage. The executor or the administrator is the one that picks the agent. So the difference being the executor is the person that's named in a will. There's also the trustee of a trust, so whoever that person is, they're the ones that's going to pick the agent. And the administrator is someone that's picked by the court. You basically, the heirs can all, whoever the heirs are, the first one to go and file the probate petition is usually the one that's ordered by the court to be in charge of this probate estate. So if there's multiple children, whoever's the first one to file and show that they're responsible enough to handle this will be in charge of managing the estate. Foreclosure in probate, so this is a common scenario that we see and that can sometimes become problematic, right? The person that was paying the mortgage passes away, and now the mortgage isn't being paid, so now it's in foreclosure. The family or the heirs, there's more sense of urgency. They need to go ahead and go find an attorney or do it on their own, but they need to file probate, and there is a motion within probate to stop the foreclosure, assuming there's enough equity to pay the liens that are on the property, the mortgage liens, within a reasonable time. For all scenarios, you want to avoid foreclosure. Foreclosure is kind of the worst thing that can happen to your client. If a home is worth 1.5, it'll likely go to foreclosure for like 1.2, and that's just lost equity, right? So whatever you can do to help avoid foreclosure is the goal. Will, trust disputes, and title disputes. So yeah, this is common where the heirs, after someone passes away, will take issue with a will or a trust and claim that it was it's unlawful, that it was undue influence. So typical fact scenario: deceased person signs a will, leaving his entire estate to his girlfriend. Then the children, of course, will be upset with that and can allege fraud, forgery, or undue influence. So this is pretty common, but in those scenarios, whoever is contesting the will or contesting the trust will have to hire an attorney to up front to go and pay their fees and file those motions in court. Title disputes, where someone's disputing title, as I mentioned before, that's an 850 petition, is also pretty common. Can take a long time because there still has to be an evidentiary hearing where the judge hears all the testimony from everyone and then makes a ruling as to who owns that property. So this, an example of this could be where maybe the person that died should have been on title. They were the one living in the property, but they weren't on title. Maybe it was in a brother's name or it was in a daughter's name or something. So one of the heirs could go ahead and file a petition on their behalf saying, no, that should have been in so-and-so's name, and here's why, and here's my evidence, and here's my witnesses. The probate process, so authenticating, you got to go and authenticate the last will and testament or a trust, right, if they have one. Does anybody know the difference, really, kind of what the practical differences between a will and a trust? A trust is better, yeah, way better. So a trust will go ahead and allow the estate to go and be out of probate. You save on attorney's fees, it's a much quicker process, and in my experience, it just avoids a lot of the litigation that can go ahead and come up because these things are notarized, there's usually witnesses, instead of, maybe a will was just signed by someone, without witnesses or a notary. So then the second step, if there is a will or there is no trust, you got to appoint the executor or the personal representative. Then that person has to post a bond, right? Because they're kind of responsible for a lot that's happening. And then you got to locate all of the decedent's assets. So again, bank statements or bank accounts, 401ks, cars. Then you have to determine the date of death value. So what was the value of all of their assets at the time of death? Then you got to identify and notify all creditors, and this is kind of where medical bills, come into play. And judges are very sensitive to this. They want to make sure that any medical bills or liens are notified and included. And then paying the decedent's debt. So any other credit card bills. Preparing and filing tax returns, have to go and file those, and then finally distribute the estate. So right here, step 9, that's where finally the property, or maybe they have multiple properties, is ordered by the court to go and be sold, and then the assets distributed per the court's order. So does anybody have any questions on probate?
There's one that once the attorney signs it, like you don't have to go to court. Once the I forgot the term, where it looks like it's no probate. I mean, it's simple. Once the executor it's appointed, then you usually don't have to go to court. What is that called?
So the trust, right? If you have
even a probate, isn't it?
Well, you could have a simplified version, technically, that avoids this process. There is a specific act where if you want to go and do this independent of probate without the court's supervision, you could. Or if it's less than $184,000, then
maybe
you can do
that's
that.
what it was. Because I sold a house in probate way back, and the executor died during the process. It was one of the sons. But then the other brother just went and get it reassigned to him, and we didn't have to go to court to get the. But it was, it was when the houses were like less than 100,000.
Yeah. Yeah, so it's probably less than the 180,000. Does anybody send advertisements or anything to kind of target these potential properties? I'd be curious, actually. All right. The next subject: dual agents in real estate sales. So they really wanted me to talk about this topic. This is a big issue of litigation. So let me tell you a quick story. There's an actual case that's going on right now. You're a real estate broker who previously sold a home to a couple. You walked the property with them, you showed them every detail of the home, answered all the questions, and then 10 years later that couple comes back to you and says, hey, we're ready to sell. And so they hire you to go ahead and sell that property and buy another property. And as you're walking through this home that you sold to them, you notice that there's a bunch of improvements made. There's a bunch of upgrades and additions. There's a new barbecue, a new side house, a new bathroom were added. And so you think to yourself, I wonder if they got the proper permits, because they didn't have this before, but you don't ask. And then in the next few days, a potential buyer comes to the house and says, hey, I like the house, wonderful space, and is all of this permitted? And you answer quickly because you want to sell this home, you want to go ahead and do your job. And you say, to my knowledge, everything is properly permitted, and it gives added value. So we'll come back to this story. But yeah, dual agents and fiduciary duty. A dual agent is, of course, a real estate agent who represents both the buyer and the seller in a real estate transaction. The California Association of Realtors puts a higher standard of care on dual agents, as they can't have a conflict of interest representing both sides of transactions. And the agent must act with utmost care, acting as the dual agent in the instant transaction. So I'm just surprised that dual agents are legal in California. As an attorney, I can't go ahead and represent both sides. It's like a big, huge no-no. Even if I represented one client before in something totally unrelated, I can't represent, the other side against them in the future. So the biggest thing is really you have to understand that if you are going to go ahead and represent both sides, it's going to require that you do go above and beyond, in my opinion. Just really go above and beyond on everything that you're doing. Really know everything about that property inside out.
I have a question. I heard about this, and I was concerned when I heard there was an agent that not only represented both sides, but she was also purchasing the property. And I thought, I don't think I would.
Yeah, I mean that screams. If the seller wants to, they could could file a lawsuit for breach of fiduciary duty, in my opinion. Yeah. Yeah,
When
that's,
she did that, I'm like, I think I'd be much more aware and concerned,
yeah.
and maybe have somebody else in the office represent, that part of it.
Yeah. I have a case right now where the agent is representing both. It's a little lower brokerage fee, 4%, where usually it's like 5 or 6 for that price point. And the last name was Lopez, the same as his. So I was like, is this your relative? I was like, I just need a check, because if this is your relative, like I can't, sign off on this. And I told him, like, make sure that your comparables are good, that the sale price, you're really confident that this is a fair sales price, because if the seller has any complaints about, hey, you should have sold it for more, they're going to come back and file a claim against you. What is fiduciary duty? So a real estate broker has a fiduciary duty to their client, whether they be a seller or a buyer, and that duty is accompanied with by the highest good faith and undivided service and loyalty. A fiduciary must disclose to his clients all the information it possesses that is material to the client's interest. A failure to disclose material information is constructive fraud. Really, this just means, right, that you have to put the client's interests ahead of your own. And in a dual agency representation, I find that very difficult to do. So I would get everything in writing. And if you're going to do a dual agency, get every single little thing in an email, send it to them, make sure they understand their options, right? If you have an inspection going and there's 10 things that need to be repaired, let them know, hey, you can negotiate here, you could go ahead and here's your options, and then whatever you decide on, put on writing. I have a lot of cases where really if the agent had just sent an email confirming the discussion, they would have saved themselves a lot of trouble. Disclosure requirements. The dual agent is obligated to disclose known facts materially affect both the value and desirability of the property to both parties. So you got to do that to both. This includes half-truths, right? And if the agent makes a representation that is not false but intentionally misleading, absent full disclosure of additional facts known to him which qualify the initial representation. Disclosures must be made in good faith, which means honesty in the fact and in the conduct of the transaction. So that's in the code. And so we go back to our story. You say to, let's say you told the potential buyer, to my knowledge, right, everything is permitted. Well, that would be a half-truth and a misrepresentation. Whether or not the unit is. All of the new structures are permitted. And I think you do not fully disclose, that agent did not fully disclose in accordance with law, and so that could be a problem. Anybody have any questions on kind of that hypothetical, or have they been in that kind of situation? Do you guys go out and inspect and verify permits? No. Okay. Yeah. Well, that would be my advice. If you're representing both, definitely add that on the to-do list.
I have a question.
Mm-hmm.
Shouldn't that be on the tax records if they had a permit to add on to the house or whatever? Isn't it on the
It could be, right? If they increase their square footage, then it could be an opportunity for a reassessment of the taxes. Yes, but I would go straight to the actual permits filed with the city. Yeah, and verify that. That's a lot of. Okay, so one of the recommendations, of course, is reconsider, maybe not be a dual agent. It definitely exposes you and your broker to a lot more liability. In practice, this could mean, working with another agent and saying, hey, if you get an opportunity, you can represent the buyer here, and vice versa. I think that's really smart and safe. Become fully informed about the property details, go above and beyond, be transparent. Even if you don't think it's material, disclose. More is better. And of course, try and be dispassionate, and represent both buyers and sellers and giving them their options. Get everything in writing. And if you do not know a certain legal question, of course, refer them to an attorney. As an attorney, we're pretty affordable during the transaction. It's after the fact. After there's a problem and the property's already been sold, then it gets very expensive at that point. But beforehand, about a $1,500 retainer usually. Maybe you're paying for an hour or two of our time just to say, okay, does this look right? And then I think it also helps with the appearance of impropriety. You're like, hey, I wasn't sure, so I recommended the buyer to talk to, counsel. I think that's a good thing to think about. What you should not do, intentionally uninformed, yeah, right? So go look, tell half-truths, and represent yourself instead of the client. All right. Any other questions on dual agency?
Is that the same as if listing the same office, the listing money to represent the buyer in order to sell in the same office? Same brokerage?
No. Yeah, different agents. Yeah, so the agents are the ones that are going to have the fiduciary duty. So I think you can go ahead and avoid a lot of issues even though it's in the same brokerage, if it's different agents.
Okay.
All right, this is one of my favorite topics, partition disputes. So what is a partition? A partition is a term used in property law to describe an act of dividing the property interests of two or more persons. A partition allows the property interest holders to be properly compensated if the property is sold, and normally lis pendens is filed to let everyone know that this action is filed. So we'll go to the next slide because it'll be good. Partition stems from a disagreement, or maybe non-disagreement, between the parties on the ownership or possession of property in which they're entitled. So you have multiple owners of a piece of property, and one of them wants to be bought out or wants to force a sale. I found that not a lot of people know that they have an absolute right to file a lawsuit, force a sale, and get their proceeds, their equity, right, out of the property. And so you can represent, even if an owner only owns 1/10 of a property, you can represent that one person, forcing a sale for that 1/10. Partition action can be filed by any co-owner, no matter how large or small, and this can also include commercial property, residential property, vacant land, and even personal property that has multiple owners. So this could be an expensive car collection or jewelry, owned by multiple people. You can file an action in court to force a sale or a buyout. Same thing, businesses can also be forced, of course, to be sold. And so if you have multiple owners, one owner can get bought out of his interest in that business. So partition by sale is the most common, and that's where the judge will go ahead and appoint a referee, who's basically another real estate attorney who represents the court and manages the sale of the property. So the judge will appoint that referee, and that referee will hire a real estate agent to sell, and will also give the court any feedback on, if anybody was cooperating, not cooperating, issues with tenants. They'll go ahead and manage that. Once the property is sold, the partition action continues into the final phase where the proceeds are distributed, and the proceeds are based on usually the ownership interests and offsets. So two people own the property, it sells, each party will go ahead and get half of the proceeds of the property after it sells. Now there's also other arguments, like if one person was paying the mortgage and the other person wasn't, if one person was using the property and locked out the other party, there could be really significant arguments as to additional offsets and reimbursements that person is entitled to. Attorney's fees and costs can be ordered by the court depending on the facts and arguments presented before them. And also, attorneys can be paid at the end, just like the agents are. We can be paid out at the end of the sale. This applies to probate and all the other topics after this too. So I think that's good to know, right? If your client is like, I can't afford an attorney, well, okay, talk to them. We can go ahead and put a lien on and be paid out of the sale. Partition in kind, I get this question. I've never had it happen, and we've never done it, but theoretically, if you have a piece of property, it's like a vacant lot of land, you can go ahead and the court could cut it in half, give one party half of the vacant lot and the other party the other half. That's super rare, and most of the time the people just want to sell and get their proceeds from it. Partition by appraisal, so that's where instead of selling the property, an appraisal is done, and then one of the parties can go ahead and buy out the other owners. Requires all of the consent of all co-owners, with the exception of this act that recently came into play. So we're going to be seeing probably more of this as legal strategy. But in January 2023, the Partition of Real Property Act passed. And basically it says that if you get served with a partition lawsuit, then you have the right to force a buyout. You can buy out the other side just by an appraisal. So you don't need the plaintiff's agreement. You can just say, hey, you served me with a partition lawsuit. I don't want to sell. I want to keep this. Let's get an appraisal. I will buy you out. And so I think this is pretty interesting. And they're trying to, the point of the act is really to try to keep properties within the family. Partition referees, so yeah, they are the neutral party. Their fees also get paid at the end of the sale, from the sale of the property. And they were the ones that usually hired the other brokers to sell the property. If you have a client that's in a partition and they're not cooperating, they can get penalized. And I've seen, $15,000, $20,000 sanctions being issued by judges for failure to cooperate with the referee in them doing their job of selling. So any questions on partitions? Has anybody dealt with one? Maybe?
Well, I worked in a law office.
Oh, okay. Yeah, yeah.
It was pretty easy. You just
It's pretty straightforward, yeah.
Yeah, just got an appraisal
Mm-hmm.
and then they split it, so.
Yeah. Yeah, it's very common right now because you see a lot of families going in on properties together. The boyfriend and girlfriend buy a property, and then it doesn't work out. I have one case where they're still living in the property, and the girlfriend has a new boyfriend with their children, and it's just it's like Seinfeld, or Springer,
Yeah, this one was just two brothers.
Yeah. Yeah. So if they can come to an agreement, that's always the better option. I negotiate a lot of these before going to court, and we just agree on who's going to be the agent, and usually they already have someone in mind. All right, clearing title. So what is an action to clear title? A quiet title action seeks to determine the actual owner of a property. It is the dispute over the property in which one party files a lawsuit to negate a claim or interest to property. Any kind of ambiguity. So for example, a party may ask the court to void another party's claim to a piece of real estate, boundary disputes, correct any kind of chain of title. Maybe there's a lien or a judgment on there that shouldn't be there. So all of this really falls under this kind of very broad title, cause of action called quiet title. When do parties file a quiet title action? When there's liens, again, same issues. Conflicting documents, basically just a question on the chain of title. So if, in order to get title insurance, you need to go in and clear up some issues, and usually it comes to our attention. The client, this person wanted to sell the home, and then they find out that there's 3 people named on their property that they've never heard of. And that's because they went to some foreclosure consultant 10 years ago, and that person put 3 people on title and started filing all these BKs to avoid foreclosure. So we file these quiet title actions, usually no one responds, and then we get a judgment. That judgment is recorded on title and given to the title company, so they'll go ahead and insure the sale of the property. What is title, right? It's who owns the property. The lawful ownership can be transferred from seller to buyer, and title must be clear, must be undisputed, and all liens or encumbrances must be dealt with. Same thing with judgments. We could go ahead and file an action to get rid of a judgment. Maybe it's the wrong name. That happens a lot. Like, it's the same name but wrong person, and they're like, I don't remember this lawsuit. That's not my car. I wasn't in that accident. The process of quiet title, they must file in state court where the property is located. So if the property is in San Diego, they got to file in San Diego. Lis pendens has to be filed, and of course this is a cloud on title, and it's protection so that anyone that takes a loan out, and tries to put a lien on the property, they're doing it subject to the outcome of this lawsuit. I have seen properties that have been sold while lis pendens is pending, and then I'm like, okay, well, if my client wins their case, then you get nothing. And so I was pretty bold of this all-cash buyer, I thought, to go through with the sale. Once both sides have presented their information and claims, the court makes a resolution, the judgment binds all the parties involved. You can also, one thing is if someone that shouldn't be on title, right, let's say they forged. There's a lot of forgery going on, unfortunately. Let's say this person forged a document to be put on title and then took money out. What happens with those loans? Well, we can go ahead and attack those loans as being void, right? Because if it's forged, then it's void. Now, if the person actually signed the lien or signed the title over, but didn't really know what they were doing. If it's their signature and then there's a loan taken out, that loan's kind of stuck with the property. So that's a big difference, and yeah, that happens. Okay, and the title company received the judge's order and issued the title policy for the property. Adverse possession and slander of title are both kind of sub-versions of a quiet title. Adverse possession is when someone is not on title and they can make a claim for ownership, basically due to the real owner kind of abandoning the property. And so this is where you see and hear those stories of people just squatters turning into, now they own the home. If you are in actual, what I like to see if I'm going to file an action for adverse possession is actual possession. That person's living there, they're maintaining the property, they're taking care of the yard, and they're paying the taxes and any home expenses for 5 years. If they're doing those things, then they have a strong case to say, hey, I don't know where the real owner is, but I've been managing this property for the last 5 years, I should go ahead and be given title. And under the law, that's an option. The public policy reason for that is that the state doesn't want homes to be neglected. They want homes to be managed and taken care of. Slander of title is when someone is forced to clear title because of another person's false, and the term is disparagement of title, but really it's just like, again, forgery. This would include forgery, somebody filing something, recording on title that they know they shouldn't do. And the special part about slander of title is that it allows for attorney's fees. Whereas just a regular kind of misunderstanding, maybe the person gave the property to their nephew or niece for like safekeeping because they're worried about Medi-Cal or something. In that instance, you're probably not going to recover attorney's fees. But if the person said, hey, sign this document, it's to go ahead and get a new loan, but it's actually a deed giving title away, then we can go ahead and ask the court for attorney's fees. All right, any questions on quiet titles or adverse possession? Let's find fun. All right. Foreclosures. What is the foreclosure? Is the legal process that forces the sale of a home to cover a debt. The lender can force the sale of a property like a home. That's of course in the deed of trust, the power of sale. And if a homeowner defaults on a mortgage, the bank can sell to get paid what they're owed. In California, lenders can foreclose either through a court foreclosure, going to court, or non-judicial. And the most common one is non-judicial. There's in almost all mortgage documents, that deed of trust, there's going to be that power of sale, allowing for the non-judicial foreclosure, and that's the most common here in California. I've done some judicial foreclosures, and there are some benefits, but it is a much longer process. So less costly for non-judicial, most common. If there's no deficiency judgment, that's kind of the big one. So if the money from the sale does not cover what they are owed, the lender cannot go to court to get an order to collect the rest of the money, right? So if the home's upside down, and the bank forecloses, and there's still another $200,000 owed, if the bank went with the non-judicial, they can't go ahead and go after the borrower for the additional $200,000. Judicial foreclosures are longer, but does allow for them to seek the deficiency judgment, but there is a right of redemption. So this is another reason why it's not common. Because if you go to court for judicial foreclosure, then the borrower, the owner, has the right to go ahead and pay what's owed, satisfy the debt within 3 months. If the sale satisfied the debt, then they have 3 months. If it did not, then the homeowner has a year to redeem the property, which is pretty rare. The judicial foreclosure trustee. Yep. So basically, you just got to go ahead and go through court. There's a publication period. Trustee's deed upon sale is where that's the document that transfers, after a sale happens, transfer the property from the former owner to whoever bought the property, and it must be sold at auction to the highest bidder. There's all kinds of rules and technical issues on, they gotta pay in cash, and if the cash or the funds need to clear within 14 days, and each bid is an offer. You can't, the bidders can't change their mind later. All right, and then the timeline. So I thought this was the most important thing that agents really kind of need to be aware of, right? Is in general, I don't think it's on here, but when a homeowner stops paying their mortgage, it's about 90 to 120 days before the bank can go ahead and start the foreclosure process. After that 90 or 120 days, then a notice of default is recorded on the property. They'll get notices, and they're going to get a lot of advertisements from a lot of people trying to help them. So it's hard to believe when our owners are like, I didn't know there was an issue with foreclosure. Well, you got like probably 100 things in your mail like for a week or two. And then once that notice of default is recorded, then the 90-day clock starts ticking until the bank can go ahead and record what's called the notice of trustee sale. Now, before the notice of trustee sale, but after the notice of default, the homeowner only needs to pay back what they're behind on. So if they've missed 12 months of payments, they just need to pay those 12 months and they can avoid foreclosure. After the notice of trustee sale, now technically the bank can require that they pay everything that's owed. And obviously not, most people aren't going to be able to do that. So also before the notice of default, the bank is supposed to reach out to the homeowner, talk about options to avoid foreclosure, and there is a little checkbox that the lenders are supposed to go and check off. Sometimes they don't reach out, that we can file a lawsuit based on that. And then the notice of trustee sale, so that's recorded, and then the earliest sale date could be 21 days after that notice of trustee sale is recorded. So all in all, you're kind of looking at 7-8 months, from the point where someone misses a payment until they could possibly lose their home. And this is where I think a lot of people, because of personal financial situations have changed, or maybe they bought too much house than they can afford, this is where you really want to advise them, listen, as much as maybe the bank is promising you a loan modification, maybe you have to sell, and that's going to be the best option. Sell, downsize, and avoid this foreclosure. And mortgage dual tracking, so this was what the case that I was published on was based on, and that's where the lender is reviewing your loan modification application, the homeowners, and then at the same time, they're still continuing with the foreclosure process. If they're doing both, that's a violation of California law. It was a big deal. They were doing it all the time 10 years ago. And so they're supposed to give you a denial letter, right? They're supposed to review your modification, either approve it or deny it, and before moving on to the next step in the foreclosure process. So for example, they can't file a notice of default, they can't file a notice of trustee sale, and they're not really supposed to have sale dates even pending while that process is happening. Yeah, I mean, any questions on dual tracking or kind of loan mods? The clients could, this is the options, right? They could sell. If they're behind on the mortgage, they can either sell, file bankruptcy, Chapter 13, or file a lawsuit to stop the sale. So homeowners do have some options. They just need to act. Ignoring an issue is never going to help them. And as real estate agents, whether the current homeowner, you want to find out, right, is if their home is in foreclosure. And right now, it's kind of easy. You just kind of look on Zillow and it'll tell you, the home's in foreclosure. We have a client right now who's signing up, and the agent was representing her mom who had multiple properties, and 2 of them started falling into foreclosure. But the agent didn't check if there was a foreclosure happening. And the home was foreclosed as she was in the process of trying to sell it. So that was really problematic. Hopefully we'll be able to reverse it, but always check with your clients. Are you current on your mortgage? Is there a foreclosure issue that we need to resolve? Yeah, because otherwise you could be held responsible for negligence or breach of fiduciary duty if you're not aware of the foreclosure issues. And more things to watch. Tenants' rights after foreclosure. So after a home is foreclosed, tenants do have a right to continue with their lease as long as it's a real lease. That's an arm's length agreement. The tenant has to show proof of that lease. But if so, then the new owner, usually an investor, has to honor that lease agreement. One other thing I'll notice on just the tenants and stuff is that if you're representing an investor as a buyer and there's other people in the property, I would inquire who are those people, right? Are these tenants? Are these family members? Do these family members have any claims to the ownership of the property? because if trying to just ignore that issue could be a problem and a basis for reversing the sale completely. So you want to know who's living there, and ask for copies of the leases. Real estate agents representing a buyer or seller during foreclosure should know the law, check the status, and just understand. I think understand that process, right? NOD, NTS, and then sale. So any questions on foreclosures?
I did see a house that was foreclosed, and it was on MLS for sale, but the people that previously owned it were still living in the house. And they said, of course, it was drive-by only, couldn't see that inside of the property. And my client, we talked to him, and we both, thought, wow, this could take a long time to get these people out of this house, and it's unknown amounts of money in court, trying to get these people to leave the property. I was amazed that they were selling it with
Unknown people in possession.
Yeah. I thought that was, it ended up not selling, and they ended up selling it to another bank, and they're just holding it, I guess.
Yeah. So I'd be very careful, in advising a buyer, to buy a property that has drive-by only, or any kind of situation like that. I mean, you could be walking into a whole fraud situation. There's a lot of fraud that's going on. And of course, there are certain, if you are going to represent a seller who's in foreclosure, there are certain forms that you have to have the client sign to go ahead and list and sell that property. Has anybody sold any foreclosure properties or dealt with those forms? It's a good thing, because you're saving someone's loss of equity if you can help them avoid, sell before the foreclosure happens. So I think that's a real good win-win for owners and agents. All right, so that's the presentation. Gomez Law, my law firm. We have myself and 5 other real estate attorneys. We have a department focused in on probate, real estate transactions, more what I'm focused on right now, and foreclosures. So if you ever have a question for yourself or one of your clients, feel free to reach out, give us a call. Our consultations are free. If you'd like a copy of this presentation, email us at social@gomezlaw.com, or just give us a call for any case questions.